ladies and gentlemen, if I could have your attention, please. Good morning. Just a few more people sitting down. Okay. Good morning. Welcome to the Welsh Autism Show Aberystwyth 2018, and welcome to our first seminar, which is being presented by our show sponsor today, Sinclairs. The title of the seminar is The Changing Face of Education Law in Wales, and we've got Christopher McFarland delivering this seminar for you today. So, ladies and gentlemen, please welcome Christopher to present your seminar. Thank you very much.
Good morning, everyone. Thank you very much for joining me this morning, and we're very grateful and proud to sponsor this event. We came to the event in Cardiff, which was a huge success, and now we're up in Aberystwyth, where I graduated from a little while ago now. I won't say exactly how long. And we're back here to talk about, the changing face of education law in Wales. Like any good academic journal, it's got a very evocative title for what is normally a very dry subject, to sneak you in and then give you a lot of law talk for half an hour. So this is going to be a deep dive on the law, because obviously it is quite a complex subject and we only have half an hour, but it goes through some of the key changes. And of course, there is still so much we are yet to learn, as we are going to find out what the regulations and codes of practice will end up looking in their revised and ultimately final form. So they're going to put the flesh on the bones of the law we're going to talk about today. But this just give you, I suppose, a few key indicators of what's going to be changing in the near future, and talk about, what we think about those upcoming changes. I just want to check, can everyone hear me at the back? Excellent, so let's get started. So, first of all, I'm just going to start by talking about the current law in Wales. Now, some of you may be familiar with this, obviously some of you may not. But we have here, preschool and school education. That's currently governed by the Education Act 1996, Part 4 in particular. It deals with, obviously, special educational needs, and it talks about, really, statutory duties that impose on local authorities and governing bodies about how to help young people with special educational needs. So, how do you, identify those needs? What do you do once you've identified them? How do you decide what provision, which is the kind of in-class or in-school support that meets those needs? And also, how do you decide where that person should be based? What school or college or whatever they should go to? So, of course, we're then looking at specific duties and detailed entitlements. So, the reason that's there is because it's a very detailed act. It's got a lot of sections, and it's quite clear about what people should do and when. And the beauty of that is that it's quite certain. You know when you have an entitlement, you know when the local authority has a duty, and that makes it better for everyone, we would say, because it's much easier to comply with the law when you understand it, it's quite clear, and obviously it's much easier to know when that law is not being complied with, and when your rights aren't being upheld, if you're an individual thinking, well, hang on, I'm pretty sure I should be getting slightly better than this. So, it's quite a good act, and it's stood the test of time, really. They talk about how the statementing process is quite a long process, and it can at times be harrowing. It depends on your individual experience. But people are quite satisfied once they come out of that process and they have a statement. Generally, they find it's quite a good experience, and their life becomes much more certain thereafter. So, it is working. So talking about statements, so statements of special educational needs, for those of you who are unfamiliar, it's actually a document that sets out across various parts what an individual's needs are, what provision they require to meet those needs, and obviously which school or educational institution they will receive that education in. Okay? So it's quite a simple document concept, but obviously given the complexities of needs that it can deal with, obviously autism, but also quite severe learning difficulties, the actual substance of the document can be complex, but its structure is clear, and it's a document that's well known. And essentially parts 2, 3, and 4, so needs part 2, provision part 3, and obviously placement part 4, those are all enforceable against the local authority. So if the local authority, in provision and in placement, doesn't comply with the contents of the statement, you can challenge that and secure what's called mandatory orders. You can get them to do it through going to the High Court through judicial review. So it's, again, something that you can enforce. It's got teeth, and that's one of its most effective limbs, essentially. And then you have a right to appeal to the SEN Tribunal for Wales. So this arises in various different contexts, but particularly through the statementing process. The first step is assessment, so you ask for a statutory assessment, as it's called, and then once that's complete, the local authority determines whether or not it feels that you need a statement. Is it required to secure the provision that you require for your needs? And then once they've written the statement, if they decide you're entitled to one, they then decide the contents of that statement and its placement. So of course, at each of those junctures, if you disagree with the local authority's decision, you can take them to the SEN Tribunal for Wales and challenge that decision. And the beauty of the tribunal is, unlike a court which relies heavily on expert witnesses to give it that expertise to decide cases, the SEN Tribunal has an expert panel. So it has a judge as a chair, and it only has 2 wing members who are educational experts who have their own expertise to understand and even determine the needs of the individual and their provision. So it's a specialist area, so they aren't really fooled or bamboozled. If someone says, oh, this child has this particular needs and that means this, they'll say, well, actually it generally doesn't. So you need to explain to us a bit more why that's the case. So it's very, very good. It's an effective means of upholding individuals' rights. Now, when we get to the further education, so the college system is currently not covered by the statementing process. That's covered by the Learning and Skills Act. And that changes from special education needs to learner difficulties, more of a change in form than substance. And its main duties are imposed on the Welsh ministers, and they're kind of broad duties and vague entitlements. What we mean by that is, it's more about ensuring that there is sufficient availability of specialist institutions in the area, and also kind of anticipating the needs of individuals who may have statements or special educational needs who are entering the kind of further education sector. But because of those broad duties, unlike the Education Act where the kind of rights are vested in the individual, it can be a little harder, a little unclear when people aren't complying with particular duties. So it has less teeth or fewer teeth than the statementing process. And unlike the statementing process as well, there's no right of appeal to a tribunal. So you can only enforce any breach or any perceived breach through what's called the appeal process of the Welsh Government. Obviously that's an internal process, all through judicial review. And those are less certain because they are, they're less clear, and that makes it difficult. Just so you know, we have a Q&A session at the end, but because of limited time, we won't be taking questions in this session. We do have a stall up there, so just come along and have a chat with us. We'd be happy to answer your questions.
That's something I think everybody should listen to.
Sorry?
There's an Equalities Commissioner you could use there.
Yeah, sure. Yeah, of course, but I mean, that's not really part of this talk for now. So, the new law in Wales, we're talking about the Additional Learning Needs and Educational Tribunal Wales Act. When was the Act passed? Well, it was passed by the Assembly on the 12th of December 2017 and received royal assent on the 24th of January 2018. When will it be enforced? Well, it's not enforced yet, that's key to remember. Although it's been passed, it needs the Welsh Government to essentially determine all the regulations and codes of practice that are going to support the bill, or the Act as it is now, and obviously then they will determine when it will come in force. Okay? They anticipate it's going to be coming in late 2020, so around about September time, ready for the start of the new school year. But of course that's not set in stone, so it is subject to change. So what's the purpose of the Act? Well, the purpose of the Act is to reform the law of SEN in Wales. So, talking about some of the key changes, as I said, this isn't really a deep dive into the law because we have limited time, but talking about some of the key changes. The term additional learning needs will replace the term special educational needs. Again, it's more of a change of form than substance, very similar tests for both, but they want to use this new term, move away from special educational needs. It includes provision for preschool, school, further education and training, and it's those latter two that are a big change to the Education Act, which doesn't currently extend further educational training. It is limited to preschool and school. As I said, the Learning and Skills Act is what currently deals with colleges. So they bring it all within one codified system, which is a welcome change. It still excludes higher education, so it doesn't apply to universities. The system at universities is governed by the Equality Act and also the kind of DSA, Disabled Students Allowance, which is that's generally how adjustments are made to disabled students in education, in higher education. But the Act will deal with colleges, which is a big change. Furthermore, rights of children and young people in respect to their education and training up to the age of 25, so it will extend. Now, it lapses at 19, so if you go to college, even if you're under 19, it lapses because it just doesn't apply there. But also if you're 19, even if you are still in secondary school, and obviously we do see people learn difficulties sometimes needing longer in those institutions to learn, because of course that's the nature of their needs, your statement will lapse. Okay. Normally they will have it at a discretion until the end of that school year you turn 19, so on your 19th birthday gone. But that is the current law. So extending it to 25 obviously means that people get support for a much longer period, and that certain period that we talked about with the statement, that time you have that enforceability, that teeth as it were, lasts longer, and that's again another welcome change. This is another good change. So every child and young person with ALN to receive an individual development plan. So currently there is this rather strange situation where you can have special educational needs which require special education provision and yet not have a statement. That's generally where they say that the school's delegated budget given to it by the local authority can cover all the needs of this child, so it's not necessary for a statement. Okay, it's that requirement for a statement that is currently in the Education Act, and that can sometimes lead to some of the most difficult cases because local authorities will often claim, yes, this child does not need a statement, we can take care of the needs, but that can sometimes be something they say and not necessarily materialise in reality. So sometimes the certainty of a statement is, I think, welcome for all parties, including local authorities, because the content is determined by the individual's needs anyway. But that is now going under the new system. So with the individual development plans, that now be called the replacements to the statement, every child, so if you need 1 hour TA support or full-time TA support, it will all be within that IDP system, and that's really good. There will still be differences in the way those are administered, which I'll come on to in a little bit. But it is very good because you're no longer arguing, are you disabled enough for a statement? It just seems like a kind of silly argument to have, doesn't it really? If you are disabled, you have needs, you should have those needs met. There really shouldn't be a question about that. So it's good to have that certainty now. It will create a greater administrative burden for schools because they're pushing a lot of that role to schools to do those initial assessments in the so-called less complex cases. So the ones that are already being dealt with through schools' delegated budgets, they are pushing all the kind of annual review duties, assessment duties onto schools, which is something that we are a little concerned about, because we feel that teachers are already very time-pressured. Obviously, they are generally considered to be overworked and underpaid, and I think rightfully so. And obviously their main role is to teach our children. So if you're taking people away to do all these, quite substantial administrative tasks, is that actually going to create quite, an increased budget that's going to be required for that? And that's one of the big concerns we have. So the duty, you have the duty on the school, further education institution or local authority to secure the provision. So again, this is a change. So as it stands with statements, it's the local authority that has to arrange that provision. So if for whatever reason you're not getting the TA hours that your statement says, you actually take enforcement action against the local authority. It's their job to make sure the school are doing it. So even if the local authority were giving the school the money, but for some reason the school weren't doing it, that is an unusual situation, in fairness. It's still the local authority you take there, and they essentially talk to the school saying, we must do this is a requirement, and they use their powers to ensure the school complies. This is slightly different. So where a school maintains an IDP, you can't appeal them directly to the tribunal, which I'll come on to talk a little bit, but you can appeal them to the local authority. And one of the concerns that we have is that it's quite nice in the current system that where things don't quite work out or aren't working out, you have the chance to take the local authority court, so you're once removed from the people you see day to day. So it does preserve that relationship quite a bit. And that's very important because when you have a young child needs, you need the teachers to be very supportive of that child and have a good relationship with the school, because those teachers do have to work that bit harder with that young person because that's their needs. They need that extra support. So we do fear that because our schools will be writing the initial plans, and parents may very well disagree, like we see currently. When you appeal a school directly, isn't that going to erode that trust and relationship? Isn't that going to potentially cause tension that further down the line, may lead to that placement breaking down? I mean, it's a speculative point, but it's something that we've seen with local authorities. We can see families and local authorities get into difficult and somewhat terse relationships during these appeals, because obviously it's a very pressurising situation for that family. But obviously we don't want that to spread to schools. Again, with further education institutions, colleges now who've not had to deal with statements thus far, they are going to have to deal with IDPs, and again they're going to have the power and responsibility to assess at first instance and write plans. And unlike schools, you can challenge a college directly to the new Education Tribunal for Wales. So they're even going to be defending themselves through that process. So it's a real sea change for colleges, and I think that a lot of them are now starting to realise this is going to be quite a burden on them to make sure that they're compliant and essentially administratively prepared, because these are time-intensive exercises. And of course, you are, unlike local authorities where go through the statutory assessment process currently, they have educational psychologists, they can look to help get, speech and language therapists, occupational therapists, that level of specialism on board. Well, schools aren't going to have those resources straight away. And it's up to the school to then identify when they need those types of support, and then that's when they can refer up to the local authority to ask it to conduct the assessment. But there's quite a burden on the school to have that realisation, and also then have confidence in its relationship with local authorities to make that request. Again, another thing we see quite commonly is that schools will feel this child absolutely needs a statement, but even though they currently have the power to ask the local authority to undertake an assessment, they ask the parents to request that for them because they feel that the local authority don't want them to ask for statements. They feel under pressure, whether it's explicit or implicit, they don't want to ask those questions. So if that's already the case now in the current system, what's it going to feel like where the burden is already on the schools? Is it going to make that relationship, that cooperation better, or is it possibly going to create more internal tension between local authorities and schools? And then the final point here is that the rights to review of decision-making in IDPs, ultimately a right to appeal the Education Tribunal for Wales. So again, when it's a school, you have a right to have it reviewed by the local authority, who may then conduct further assessments themselves. They may adopt the plan, they may amend the plan, and then if you're still unhappy with the way the local authority treated it, that's when you get the right to go to tribunal. With further educational colleges, all plans that are already held by the local authority, so where children currently have statements, it's tending to, people are telling us that those are going to go straight to local authority. They're not going to put those to the school first because they recognise those children are sufficiently complex that they're going to need that level of specialism that is going to remain available with the local authority. So that's the kind of key changes that we see. So just in this short talk, just talk about some potential pros and cons. And again, we say potential because, we've been to all the Welsh Government talks, went to all the Welsh Government seminars, and we're part of the consultation process for many years. I mean, this has been many, many years in the making. And they're obviously very positive about the bill and now act that they've drafted. And I suppose rightfully so. It does do a lot of good things. One codified system for young people with ALN from birth until 25. That's good. It gives them a long period to be supported by one system, and although that IDP, like I said, will grow with them through the annual review process, so they'll keep looking at the support, see does this need to change, have the needs change, does the placement need to change. That will happen with the IDP, but that document will stay with them, unless there is a point where they somehow recover entirely from their needs, which I would say would be extremely, extremely rare. They will have that document all the way to 25, or as long as they need it, and I think that's very, very helpful. Again, all children with ALN to receive an IDP, again, it just stops that argument of, are you disabled enough for a statement? Essentially, are your needs such they require a statement? I mean, it always seemed a bit of a silly argument, I would say, and to get rid of it, I think, is helpful. You have needs, you require provision, okay, let's put that in a document where it's all laid out and it is enforceable. I think that's much better for everyone, much more clear. And obviously the jurisdiction of the tribunal is extended, so whereas before we said further educational disputes as they currently are, you don't have the right to go to the tribunal, now you will, under the new system. So that's, again, a welcome thing. You can use this expertise to your advantage. And of course, it's also good from a cost perspective as well. I mean, the problem with, especially with the limited legal aid availability we have these days with all the cuts, it's often when you think, oh, well, I can enforce my right, yes, but it may cost £20,000 in, barrister and solicitor time, and that's just because it's such a long period, 6 months or so of work. And then obviously if I lose, there's a risk the local authority could enforce its costs against me, so I could be facing bills of 40,000 plus. And all of a sudden when you're faced with the risks of that, people start to think, well, maybe I should just let sleeping dogs lie. Maybe I should just put up. with the system that I have. And obviously, you know, that's not really a satisfactory position, is it? You know, we want people to feel that where they feel wrong, they can get heard, they can get supported, and ultimately we want to see them have the right decision. And because the Education Tribunal of Wales, the SEN Tribunal as it currently is known, doesn't have a costs system, you can only claim your costs in very limited circumstances, but there is no cost follow the event rule, which is where the winner basically gets their costs from the other side. That doesn't exist. So it means your risks are much more limited. Because of the flexible nature of the process, it's also much cheaper to go to as well. And it's also, if you want to represent, it can even be free. So that's a really good thing. So it means that people can actually pursue their rights without risking their livelihoods or potentially bankruptcy to enforce them. And I think that's definitely a good thing. So potential cons. So again, a lot of this works on, are schools and colleges going to have the budget or the expertise to kind of deal with these new and extensive responsibilities they're getting? And that is a big if right now, a big, big if. They're being asked to undertake assessments, and essentially the whole system is contingent upon them recognising when the young person or the child is too complex for their understanding. Now that may seem like a pretty obvious question to your eye, but when you're under pressure to not say those things, or perhaps when the needs of the child are perhaps so specialist that they mask those needs, and you may not even know or comprehend what those needs are, how are you then going to realise that? Sometimes it'll be obvious, sometimes it'll be not so obvious. So there is a risk that needs may go undetected for longer, and young people may not get the support. I mean, I had an example in the current system where a young boy got to year 9 in a mainstream school before someone said, oh yeah, he's got moderate learning difficulties. I mean, how did that go undetected? How did no one realise that young boy is not following that lesson at all? How did that just go missing? He's been in school for years, 10 years, I think, if you include reception, and nobody spotted that. So there is a concern. If that can happen in the current system, what's going to happen where schools are now required to do the initial assessments? That's our big concern. Again, the potential conflict with parents, as we say, it's quite useful to have that debate once removed, as it currently stands. And we are concerned that, if for whatever reason schools and parents disagree on the assessment or the content of a plan, which is often, that happens regularly, there is a risk that that can strain relationships, make things difficult, and then, even if you win and you get the plan you want to the end, can you stay in the school longer? Or are you at such loggerheads with that school that you feel that it wouldn't be in your child's interest to stay? And then, of course, we say potential for internal disputes between authorities and educators. So part of the, appealing the decision of the school kind of up to the local authority can either adopt the plan itself, say, right, we'll take over from here, don't you worry. Or it can say, you know what, we think it's right, we're going to make you, school, comply with this. Or even if they change it, they can still say, no, we think the school should be responsible for ensuring this is delivered. And there is obviously a risk that you get passed between both of them, the devil in the deep blue sea, where they're arguing, because it's generally about budget. Everyone's getting their budget squeezed, unfortunately. And of course, that puts pressures on everyone. Schools need to ensure that they're helping every child, but of course, they also need to ensure that they help this child in particular and help them with their particular needs. So, they can feel under pressure to deal with budgets and manage budgets appropriately. And again, local authorities equally, in a certain kind of age of cuts, they're always trying to save money where they can. And really that's where you see most of the cases that go to tribunal today. You have a young person whose needs require more than they're currently getting. Often it can mean that they are perhaps bringing therapies in and they are expensive to purchase for the local authority, or it's valuable time out of a therapist's day. So of course they try to spread them as widely, but where a young person needs, weekly one-to-one sessions with a therapist, that's not really a good value for the local authority. They'd rather group sessions or, internal programs, because it means that that therapist can then do more children, see more children. That's obviously a cost saving to them. So it's in those type of situations we currently see where matters escalate to tribunal, because local authorities feel that it's going to be very expensive for them to put the provision that the parents or the young person wants, or even sometimes what the reports say that young child or young person needs. you know, it can be very difficult. So we're a bit concerned that, you know, as we're now going to be dealing with two separate budgets, the school and the local authority, are we just going to have more people arguing about money? Is it just going to make the process that much longer? So those are, I suppose, our key concerns at this stage. And as I say, there is still more to learn, you know, as the regulations come through, both in the draft and then their final forms, and the codes of practice are going through revisions as well. So obviously you want to see, you know, how those change, how those develop over time, and obviously what the final picture is going to look like. I think that's important. And, you know, but for now, these are key, and these are concerns across the sector. You know, all of us who are claimant-based in law, we have these concerns. And, you know, there were a lot of concerns raised in the consultations, and it didn't lead to much change in the bill. So we are interested to see, you know, how it works in practice. We're always being told, don't worry, we'll sort that out in the regulations, we'll sort that out in the code of practice. And that's all wonderful, but if it doesn't get sorted out, there can be some teething problems. So that's really for now. I mean, as I say, this isn't a deep dive because we have some limited time. I mean, how much time have we got left?
7 minutes.
7 minutes, that's quite good, because I want to make sure we got in time. But obviously, if you have any further questions, we have our stall out there. Do feel free to come have a chat with us. We also run a series of seminars. You know, just look on our website or our Facebook page or our Twitter page. We generally, you know, have them for free in our Cardiff office. So we go into a lot greater detail there, go through sections, go through how things function more in practice as well. And of course, you know, we're always available for a chat if you feel like you need more advice. But I know you were going to ask a question earlier, and I couldn't take it.
I've got another one for you. You've said so much about the law, the way it stands, and so putting it into practice, local authorities and so forth. One, local authorities do what they really want anyway, and they don't adhere to the regulations that are even set by the Welsh Assembly. Two, the fact that all these laws that are in place now, and you are still up in the air with a lot of it, you've already stated that we're not sure exactly what's going to be put on. All our human rights laws, right, once the European human rights is closed down and the government gets hold of all of that and writes it their way, until we know what that is, we don't know a damn thing what our rights are.
Interesting point about the Human Rights Act. So the Human Rights Act is a UK government, UK Parliament statute. So although it was informed by the European Commission on Human Rights, etc., or Convention on Human Rights, I should say, it's still you know, UK Parliament is sovereign, so it's only bound when it wants to be bound, and it creates laws that it wants to create. That's its nature. So, you know, whilst there is talks about potentially repealing that, that shouldn't directly affect this system. It shouldn't directly affect this system. Because, of course, you know, this statute will be standalone, and the rights within it will be standalone, and they will be enforceable as themselves. So it's not like it's contingent on the Human Rights Act existing for these rights to be
Is that by royal assent?
No, it's just, well, I mean, it has received royal assent, but it's just the nature of statute. Statute, you know,
That's
is
where our rights
primary
come
legislation
from.
must be followed. So,
The Charter by King Richard.
sorry?
That's where our human rights come from, the Charter.
Excellent. I must admit, although I am a lawyer, I'm not a great legal historian. So, does anyone else have any quick questions? I think we have a little bit of time maybe for a question to this gentleman here.
Is there any appetite to give the statement of education release to people at the university?
Now, again, we would like to see that. Again, we kind of feel it's a little arbitrary to say, you know, oh, you were disabled your whole life with this lovely plan, now you're at university, you're okay. Yeah, I mean, it's interesting. I mean, I don't quite know what the true reason is why they didn't. I think it'd be helpful because I think certainty is helpful for everyone. You know, we deal with a load of university students through the Equality Act. I have a number of cases now. I mean, you mentioned the Equality and Human Rights Commission. We are funded a lot by them. We are one of their panel solicitor firms. So, of course, where people do have disputes with the universities, they can receive some funding, which is great, particularly, as I say, in an area of limited legal aid, to get some help. But yeah, I mean, I would like it, but there doesn't seem to be much appetite from a kind of government or parliament perspective, sadly. Same in England, they didn't extend it either. We don't quite know why, you know, but that's the way the cookie crumbles, I'm afraid, with Parliament. But yes, I think it'd be a great idea. I think that, you know, I think it's better for all sides. If you're a university and you know exactly what an adult at that point needs, you can deliver it, and you know you delivered it. You know, if it's written clearly, you know you've done your job, and you can realise you're not in trouble. You know, I've done my job, I'm fine. Whereas, you know, if it's all vague and it's reasonable adjustments and maybe they're not set down somewhere, maybe you think you've done them, but maybe it hasn't been properly investigated, you know, again, it becomes a little more vague and it's a little unclear when things are being complied with, and that uncertainty is where you get most of the disputes, that grey area. Do we have time for one more question? Is that enough?
You have 3 minutes.
3 minutes, go on, one more question. Oh, I think you were just, I think you were beating the punch just, I'm afraid. But don't worry, we have a stall out there, come chat.
The Equality Act says that you don't have to have a diagnosis to have reasonable adjustment. And all of this is based on waiting until you've got the diagnosis go through before it goes into place. It should be inclusive practice regardless. And so okay, and that's hard because it's how long's a piece of string. You know, who needs it, who doesn't. But if people, I have a problem with the fact that if people are waiting until the diagnosis comes through and everything's been put in place before they start giving the support correctly, that a lot of people are not getting what is fair for them to reach their potential.
I mean, that's true. I mean, what you were talking about is there was called a functional test for disability. So you don't need a diagnosis to be disabled under the Equality Act under Section 6. It's obviously about the long term and basically the impact it has on your ability to carry out day-to-day activities. That's the wording of the test. But the Equality Act doesn't apply to schools, so it's not like you're outside of that catchment. And I think it's not perfectly accurate. It tends to be how it works in practice, but it isn't contingent necessarily on diagnosis. It's more about identification. So you don't need, for example, a particular diagnosis necessarily to have particular support. You know, it's more about, well, what do you need? And that requires assessment. But you do have, you know, you can seek an assessment, and where obviously you haven't been progressing adequately, you can get that assessment. So because you've got the mechanism for assessment, that should be, you know, it's a time-limited process of
We got
regulations.
assessment for our son, because we got it external from the school, they said it didn't count.
Oh, those beautiful, beautiful lies. God, we hear that all the time. Also, as I said, it's not enforced yet, the new law, so don't, if anyone tells you they don't use statements anymore, that's another lovely fib. But yeah, we hear that all the time. That's rubbish. That's rubbish.
I know it is.
Yeah, that's rubbish. But those are the types of cases that we're involved in, basically. It's where, you know, people can't decide on needs, so you end up getting a bit of a tussle about, you know, what the needs are, what the provision is, and that's where the tribunal comes to come in. That's the great part about the tribunal. It's a good equaliser. You know, it will listen to all evidence, and it will determine for itself which is most persuasive. And unfortunately, you know, and this is not true for all local authority experts, because you do get some great ones. I mean, I had fantastic work by some local authority experts recently, where they basically said, oh no, this kid really needs a big package of provision, which is great. Sometimes you do get them where they are almost painting by numbers. You know, local authority policy is X, so when we see need Y, we apply X. So it's you know, that way you can get that disparity between private reports and local authority reports. I am now being told to end my talk, but thank you very much for those wonderful questions. And as I say, if you have any further questions, please do come and see us in our stall. We're very friendly and happy individuals, so we're happy to help. And obviously, you know, should you need us, just drop us an email or a line, we're happy to help. Thank you very much for listening.